Everyone, and welcome to this seminar. We are happy to see each other. COVID seems far away, but nevertheless, we are now used to meet online, and I heard that several people didn't know each other, so at least it's already a good point for today. So welcome. I'm really happy to have this discussion and presentation of the study as the defense of human rights is part of my mandate, and especially when it comes to trade and association agreements and how our relations can contribute to the promotion of human rights. And the starting point is Article 21 of the Treaty of the European Union and Article 207 of the Treaty on the Functioning of the European Union, implying that our EU trade policy cannot be disconnected from EU's broad rights agenda. On the contrary, it should even be used as a lever to promote and enforce them. And when we talk about human rights in the context of those agreements, the democratic clause that makes human rights an essential element springs to mind. And straight after that, the fact that the violation of human rights can lead to the suspension or termination by one of the parties of the deal. But let me just comment on two elements. The first one is that the appraisal of what constitutes a violation of human rights in the sense of the article is quite discretionary. It is neither transparent nor predictable. What does it take for a violation to be a bridge too far and lead to EU to take action? When is a violation sufficiently severe and enduring? And the second element is that I really want to emphasize that my goal as a Green MEP is not to suspend or terminate an agreement, because I really firmly believe that a disengagement will not solve anything, while we have an ethical responsibility to assume. And having said this, I believe that midway, gradual and concrete solutions can be found to nudge the trade partners, because they will feel that we put our act together and that we are serious when it comes to human rights. And let's also be clear, there is no question of disguised protectionism or whatever. They all abide by the UN Universal Declaration of Human Rights and by the Universal Periodic Review. At our level, the review of the trade and sustainable, it's not working?
No, it's working. You can speak just for the video.
All right. The review of the trade and sustainable development chapters of last year left aside the human rights issue, on the ground that it was out of scope unless they are related to workers' rights or the ILO conventions. This is something we saw not later than last week, when the position paper of the Commission on the ex post evaluation of the agreement with Central American countries omitted human rights, except when it comes to the important freedom of association and of collective bargaining, for instance. Despite having a democratic clause switched on and a TSD chapter, the situation has deteriorated in Vietnam since the entry into force of the agreement. NGOs are publishing these days a report on the crackdown on peaceful protesters. A delegation of the European Parliament visited the country in April, and they were flabbergasted by what they saw. It is hardly, not to say not, reflected in the joint statement following the human rights dialogue, where I quote, "The EU noted the leading role of Vietnam on the resolution commemorating the 75th anniversary of the Universal Declaration of Human Rights." In my view, and I'm sorry to be blunt here, having spearheaded the urgency resolution on Vietnam adopted 2 years ago in this House, the human rights dialogue is nothing but a masquerade. Looking into the future, the challenges loom large with the negotiations with India. The latest edition of the Freedom in the World 2022 report by the Freedom House points at India for a series of setbacks to political rights and civil liberties since Prime Minister Narendra Modi's re-election in 2019, showed no signs of reversing course, as notable opposition figures faced arrest and surveillance. As to whether the CSDDD will be devoid, it remains to be seen. It is a good move, of course, if companies have to police their supply chains and internalize the possible adverse impacts of the activities, including when it comes to human rights. But without a supportive framework, one that can be provided by a trade agreement, one that will incentivize the authorities of the trade partners, it will be difficult for the companies to fulfill their obligations. Bearing this all in mind, I commissioned a study to Professor Van Elsuwege and also Professor De Coninck, who is online. And I give you straight away the floor to give us a flavor of your findings and also of your recommendations to us. I thank you, of course, for your very in-depth contribution and analysis. And after your presentation, I will open the floor to an exchange with a guest that I will introduce in due time. Please, you have the floor.
Thank you very much for the invitation for this event and also for giving us the opportunity to work on this indeed very important topic, the relationship between human rights and trade agreements. Of course, it's not a new topic, but it remains very relevant, and you already referred to this because we have the constitutional framework since the Treaty of Lisbon very explicit, this nexus between trade and human rights in the combination between Article 207 on the common commercial policy and Article 21 on the objectives of the EU external action. So you cannot disconnect the common commercial policy from the broader objectives of the EU's external action, which explicitly refer to the role of protecting and defending human rights. So this of the presentation, which is also the outline of the study. First, as I already referred to, we have this, let's say, constitutional framework and the inherent link, I would say, between trade and human rights. Then we focused on the role of human rights clauses in trade agreements, with a particular focus on challenges of monitoring and enforcement, which is crucial. In our study, we also added a comparison with the experience of the United States, because it's always interesting to see how other important trade actors deal with this type of questions, to draw some conclusions, which we'll briefly discuss here as well. So on this nexus, as I already said, I think it's important. I cannot be stressed that, of course, we have this link in the treaties, but it also implies some implications in practice. Amongst others, we have procedural implications, such as the duty to action seriously, then it not only implies the requirement to conduct an impact assessment, but also to do something with it and to take human rights seriously in the entire policy cycle of trade agreements, including also questions of monitoring and enforcement. Now, if we look at the role of human rights clauses, these as well are, of course, not new. I mean, we have them since the 1990s. We have a gradual evolution in the formulation and scope of the clauses. Typically, we have a definition of what is the essential element of an agreement, and then the possibility of taking appropriate measures with suspension as an ultimate option as foreseen under these agreements. I will not go into the details. You can look and report for an analysis of the evolution in the scope and the formulation. What we could see, of course, is rather open-ended and broadly defined scope, which in its the practice, it appears, particularly when it comes to the question of discussing the triggering of appropriate measures, that we have limited practice there, which can be explained. I mean, we can see that there is a clear trend and preference to use measures adopted in the field of common foreign and security policy, so the sanctions under the foreign policy approach. And I mean, there might be good reasons for this, taking into account that you can adopt targeted measures. But of course, on the other hand, one could question whether the trade and the common commercial policy could not be better connected in certain situations. Just to give one example, with Russia, we have already 11 rounds of sanctions adopted in the framework of the common foreign and security policy, but the question of using the human rights clause under the partnership and cooperation agreement was never actually discussed, which, even though it might be a bit symbolic, taking into account the limited scope and significance of the agreements in practice, it remains a bit paradoxical, I would argue. As we defined in the report more specifically, monitoring and enforcement is the key challenge so far, where we could also see a kind of gap, as we announced it or called it in the report, or kind of disconnection between what we called ex ante and ex post human rights conditionality. Before the agreement is actually concluded, also the European Parliament has more stronger possibilities to influence the questions of human rights conditionality, because it plays a role in the procedure towards the conclusion of the agreement. We can see also, and other studies have been made, that there can be an impact. Studies have been there can be an impact in terms of ex ante human rights conditionality. What is needed here are predefined standards and a kind of clear, explicit commitment. Ex post conditionality perhaps is much more difficult because, well, in practice, we might see that, of course, we have human rights clauses in the agreements, but we also see that there is this practice of human rights dialogues, sometimes rather secret. I mean, I think there could be improvements in terms of transparency as well, because with the human rights dialogues, sometimes let's say the perception is that this is a kind of routine exercise, which does not create a lot of added value here. Now, a third important point is that we could also see important evolutions when it comes to the questions of monitoring and enforcement of trade and sustainable development chapters. I think here we see significant developments. They're important, and labor standards, I mean, they're of course human rights as well. So this is, I would say, a welcome development. We have the new agreement with New Zealand today. There were some important developments there as well. For this new generation with more enforceable standards on trade and human rights, we have the creation of a single entry point, chief trade executive officer. These are all significant developments, but of course, the scope is limited to trade and sustainable development and the protection of the EU's own interests. Whereas, of course, the challenge of human rights is much broader than this. We have a report, I think an interesting one, of the Ombudsman pointing at the limitations of focusing on trade and sustainable development. If we really want to have a more comprehensive approach to human rights, then, of course, some additional recommendations might be in place. I won't go into all the details for the sake of time of our comparison with US. We have Joyce, who's following online, and she's the let's say the expert also on the US approach. But the interesting part here is that we can see that the EU's approach is, let's say, to a certain extent, perhaps more ambitious in the sense that we have a kind of broad value-based approach with open references or general references to international human rights instruments, which is different from the US, which is perhaps less broad in scope, but often more rights-based and focusing on procedural requirements. So this is the kind of lesson that could be drawn. Bringing us to the key questions. I mean, what to take out of this? What's the way forward? Some general lessons first, and then I'll try to apply them to some concrete case studies, perhaps. I think coherence is crucial. As I said, we have quite some instruments dealing with human rights, and we have the possibility of sanctions under CFSP. We have a role for the European External Action Service. We have the Commission focusing on trade and sustainable development, but improving even more the coherence between the various policies and institutions, I think that's a key element, and it's, I mean, also foreseen under the EU treaty provisions. Second element, which often comes back, is the fact that we might think about a more tailor-made and flexible approach, which basically means that, well, we might have face various situations or different situations in terms of human rights challenges in various trade partners. So taking into account a specific situation in every trade partner might be important. And here, of course, the question will be what priorities are, what type of human rights we're aiming at, and what kind of additional measures we want to add to what already exists. So an option could be to focus on more procedural requirements, in addition to some substantive-based specific obligations with reference to international standards. Having a clear, transparent complaint mechanism and review mechanisms here will be crucial. We do have this now to a further extent than we have it in the past on trade and sustainable development, but perhaps expanding this, including possibilities for complaints issued by NGOs active in third countries, persons who know the situation best on the ground in third countries, that might be, I think, an important additional element to take into account. Last but not least, if we think about putting some flesh on the bones on these human rights clauses, then we might move in the direction of a more gradual approach. Suspension indeed should not be an objective in itself to the country, I would say. I mean, that's the kind of last resort that we will try to avoid. And here one might draw parallels with recent developments in other areas. Like recently we had a discussion on the EU's anti-coercion instrument. Of course, it's a different context, but if you look at the proposals on the table there, we can see kind of procedure or process which is included, with at the very last the possibility to adopt countermeasures, but with intermediate steps, options for dialogue, the possibility to set specific deadlines and engage with countries that are involved in coercion towards the European Union. Again, it's a different context, but this type of gradual approach might be perhaps relevant for human rights in itself. On the three specific cases, topical cases that were already mentioned also in the introduction, I think with India, it's an interesting case because we don't have an agreement yet. So here, focusing on this ex-ante human rights conditionality NGOs, human rights defenders that know the situation best in the country, and link it to the work of the human rights dialogue. With India, we do have this, but again, have this combination with what might be included in an agreement is relevant. On Vietnam, of course, the situation is different. We do have an agreement. It has been mentioned also in the introduction here that we have the information, basically the evidence of concrete problems. We have reports by NGOs that we know what core problems are. One of the core problems concerns the fate of political prisoners. Freedom of expression, which perhaps is broader than or is broader than trade and sustainable development. But it's just a matter of putting this also as a priority in the framework of the institutions that we have and try to set example or case is the agreement with Central America. It's a different case again. It's a broader agreement, association agreements, which is only provisionally enforced. Only the trade chapter is provisionally enforced. We still need one ratification. It's a mixed agreement by Belgium. We also included in our study a chapter on the challenges of mixity, pointing at the possibility to have also human rights clauses included in the provisional application of the agreements. It is legally possible. We have examples. We refer to the example of an agreement with Afghanistan, for instance. I mean, of course, it's not the case in this agreement, so it's perhaps a lesson for the future. But that having said, we can also draw some conclusions from the impact assessment that is available. If you go through the impact assessment, they did the same last week, then, I mean, there is very little about human rights. Also the impact, I mean, there is no clear evidence on what the impact is on improvements in terms of human rights. So here, and that's perhaps also a policy choice on behalf of the EU institutions to focus on the broader, more comprehensive human rights approach in the framework of trade relations with third countries. Take the case of Nicaragua, for instance. Part of this broader agreement with Central America. Of course, we have the problem that only the trade partner part of the Central America agreement is currently in force. But nevertheless, I mean, we have some important points of reference, such as a recent report of a group of experts on human rights in Nicaragua. The report has been discussed at UN level, at the UN Human Rights Committee, which could indeed be used as a specific benchmark to trigger potentially the human rights clause, which is also included under another agreement, a political dialogue and cooperation agreement, with which is applicable with this country, with Nicaragua. So some very general conclusions at the end. Human rights clauses are there, have been there already in the past. Of course, they're only one instrument of potentially a more comprehensive human rights policy. The question is perhaps about mainstreaming a broader human rights agenda in the EU's common commercial policy. So far, we have the focus on trade and sustainability. I think this is very crucial and important, but it's not the same as a comprehensive EU human rights approach in the framework of common commercial policy. So this would be one general conclusion. The other one is that one might think about the inclusion of specific procedural guarantees in the EU and at the level of the trade partners. Think about specific, dedicated, transparent complaint mechanisms. And the last general point is this idea of a tailor-made, flexible approach. Think specifically about what the challenges are in specific trade partners, where I think the input from NGOs and other relevant stakeholders is important. So I hope I didn't speak for too long, but
Thank you very
open
much,
for
Professor
discussion.
Van Elsuwege. Is it also foreseen that your colleague intervenes online? No.
No, but
Not
she's
today.
available if there would be
For the
particular
Q&A.
questions. Yeah.
Okay, perfect. Thank you very much. Then now I'm happy to open the floor first to the Commission. I turn to Madelaine Tuininga. Madelaine is head of unit at DG Trade, responsible for trade and sustainable development since 2016. Please, Madelaine, can you react on the presentation and maybe also give your opinion on the policy recommendations that have been formulated?
Good afternoon. Thank you very much, Saskia, and thank you very much for the very good, snappy presentation. You were certainly not too long. I'm indeed sitting here, but I'm part of a twin. I have a twin brother called Ulrich Weigel, and together we deal. We've split up. We are 2 units, so we deal with the thematic part of it and the policy part, and Javier is in charge of human rights in my unit. But of course, Ulrich manages the bilateral and GSP, so we very much work in tandem. And today it falls on me, but you can also meet him next time, and maybe next time we come together. Maybe let me outline first what we do, and then I come to the proposals put forward. So in response to the question, DG Trade is pushing forward human rights issue in our relations with third countries, and it's an integral and important part of our policy. Trade policy can indeed be a powerful factor helping to promote human rights in third countries, and you've quoted already examples with GSP, the TSD chapters, but certainly also autonomous measures, although I wouldn't qualify them necessarily as a trade tool. They have a very important interface with trade. So conflict minerals, which we happen to do in my unit. Human right due diligence, you mentioned it already, is coming up. And then we are currently working on the forced labor ban. Also that is in my unit together with DG GROW. Respect for human rights is also an essential element of EU association or political framework agreements with partner countries. And the clauses have been systematically included in all political frameworks as well as standalone free trade agreements, concluded with the EU with partner countries since 2009, the common approach. Now, the main purpose of human rights, the human rights clause, is to incentivize partner countries to engage in dialogue and achieve concrete progress on human rights issues within a wider context of cooperation on human rights. Such cooperation involves primarily bilateral engagement through human rights and political dialogues and work in multilateral fora, and Luisa will elaborate on this. And as you say, the suspension or termination of a trade agreement due to human rights violation should be considered as a measure of last resort, and I think we're fully on the same line on that. Trade relations must be understood within the wider context of cooperation and engagement with third countries. This is a complex area where responsibilities and tools are shared across different policies and services in the Commission and the External Service. The Commission has made efforts to enhance the contribution of trade policy to the promotion of human rights. And the examples are those that you quote, the CTO and the single entry point, and the adoption of TSD chapters, but also the adoption of the TSD review to strengthen the implementation and enforcement of TSD chapters in trade agreements, including by means of possible measures in response to serious breaches of fundamental labor rights. And at this moment, we're working on the reform of the generalized system of preferences to enhance the monitoring of compliance with international human rights standards by beneficiary countries. Now, regarding the study on the concretization of human rights commitments, on the standards of review and benchmarks, the benchmarks used by the EU for monitoring human rights clauses are the standards laid down in international human rights from the UN and ILO. And I can only say that now going through the European Green Deal and defending the European Green Deal internationally, how critical and important it is to to rely on international standards. We are seriously being accused of going alone as EU and setting new standards. So we rely to a large extent on the conclusions and recommendations of the UN and ILO bodies responsible for monitoring of the conventions. This is how GSP in real life works in the monitoring, and it's an important part. And Luisa may want to say more about this. On the mechanism for review and monitoring, so on annual reports for trading partners to the Commission, monitoring of the implementation of international human rights standards under GSP must be understood as a very targeted approach based on the concrete objective of the GSP regulation, which is to promote the sustainable development of beneficiary countries. And it applies therefore to a limited number of countries, the GSP plus countries. This targeted approach is not applicable to the relations with all EU trading partners. Monitoring of compliance with international commitments is rather the work that is done and carried out in the context of international organizations like the UN and the ILO. On the regular reports from the Commission to the Parliament and Council, now the Commission and the EEAS already make publicly available annual reports assessing the overall human rights situation in third countries, not only in trading partners, and also there, and Luisa may want to say more. Then on the enforcement and remedy mechanisms, the complaint mechanism for trading partners. We do have a variety of tools and instruments at our disposal to discuss human rights concerns with partner countries. There's the regular political and human rights dialogues. We have the development cooperation instruments, and we have engagements in multilateral fora. We also see that autonomous measures, forced labor, due diligence, will be an occasion for further engagement. To give you an example on forced labor, not only with those applying, those violating forced labor, but also those combating it. There's a lot of thinking going now in how we can stimulate this also to engage further with third countries in the context of autonomous measures. On a complaint portal for citizens and stakeholders, the Commission does not see the need to establish a separate complaints mechanism for citizens on human rights, and there are several reasons for that. There are already various effective channels allowing stakeholders in the EU and third countries to bring allegations of abuses by trading partners to the attention of the Commission, the EEAS, or EU delegations. This includes physical correspondence, email, context forums in the Commission or EEAS websites, and dedicated meetings. The Commission and the External Service systematically and proactively seek input on human rights issues from stakeholders in the context of relevant dialogues and consultations regularly held with third countries. This is, for example, civil society dialogues and consultations, meetings of the domestic advisory groups, and the TST and GSP working groups and expert groups. And lastly, there are human rights focal points as part of the political sections in EU delegations, and they act as key interfaces for civil society organizations and human rights defenders in third countries, including in relation to allegation of human rights abuses. So to wrap up, we fully acknowledge the importance of it, and we fully acknowledge that there's work to be done. But I think our thinking goes rather along the lines of not to think of new tools, but rather build and improve the existing tools. Work on human rights issues is a joint effort from the Commission and the External Service and EU delegation, and must be understood within the broader context of EU bilateral and multilateral relations. The existing tools and instruments allow us to gather the necessary information to take appropriate action, taking into account the specific circumstances with the aim to maximize the contribution to promoting human rights. And the key considerations in this regard are the effectiveness of the measure to remedy the human rights issue, the impact of the measure to the inclusion including the population, including vulnerable groups, and the effectiveness of the measure for achieving long-term progress on the protection of human rights. So these would be the key consideration we think we would need to look at assessing how we would need to step up or improve efforts. Thank you, but I pass it on to.
Yes, thank you, Madeleine. We'll open a round for a Q&A discussion after the speakers. I know I'm pleased to give the floor to Luisa Ragher, Head of the Human Rights Division of the EEAS. Thank you for joining this discussion. You have the floor.
Thank you very much. Thank you for organizing this meeting, and thank you for the presentation of the professor on this very important topic. Let me start by saying that as the European Commission, also the External Action Service is committing to promoting human rights in its external action of the EU. This is very much a priority. When we talk about the essential elements clauses, we have to keep in mind that these are at the intersection between human rights, foreign law, and trade policy. So it is a very, very complex issue. We share the view that was expressed that these human rights clauses are useful instruments to ensure the respect of human rights in our partners' countries, and is also part of a broader tool of instruments that we have at our disposal, and I'll come to that in a second. We have, as the study also outlines, different formulations and also different contexts in which the essential element clauses have been inserted, and some rationalization has taken place after the 2009 common approach on the use of the political clauses. You can have the essential elements in the political and cooperation agreements. You can have trade elements, including in the political and cooperation agreements. You can have a link between the two agreements with the suspension element and the essential element clause in the political agreement. Or you can have, in specific cases, the essential element clause in the trade agreement where there is an absence of a political agreement. So we have various scenarios, and the language is not identical, as you have clearly mentioned. But it's not only not identical because there has been an evolution in the language. It's also not identical because the language of agreement is subject of negotiation with the partner country. The objective remains the same. The objective of the human rights clauses is to state the expectations of the European Union that the government of our partner country should respect, protect, and fulfill human rights. So though the language may be slightly different from one agreement to the other, the objective of the clauses remains the same. It is also the framework and the conditions for us to engage with partner countries on human rights. You have mentioned the human rights dialogues with some skepticism with reference to Vietnam. I know that some of the civil society has also expressed skepticism. I would like to underline we have 65 human rights dialogues. We are pretty proud of the human rights dialogues. In our objective, and I hear that this is also something that is shared by your side, is better to dialogue than not to dialogue. And what we aim to do is to have as constructive and concrete outcomes as possible in each of the dialogues. It is certain that we cannot guarantee that by having a dialogue we make a substantive progress on human rights, nor can we guarantee that by having an agreement with a country with an essential elements clause, we de facto improve the situation in the country. You refer to the fact that having the FTA and the PCA with Vietnam has not resulted in a better human rights situation. This is the degradation of the situation in Vietnam is independent from the agreement. As regards the recent human rights dialogue that has taken place on the 9th of June, the statement is a negotiated statement, is a joint statement. And therefore, some of the elements that were discussed, and I can assure you that individual cases were discussed, that the death penalty was discussed, but some of the elements that were discussed and quite forcefully have not been reflected in the outcome document. Now, on the specific mentioning of the Vietnam resolution on the anniversary of the Universal Declaration, indeed, that Vietnam put forward a resolution that was supported by all 27 EU member states. It happens that countries that do not have a perfect record have a positive initiative in the Human Rights Council that is then voted by consensus. And in fact, the policy of the European Union has always been to differentiate and to seek partnership on issue-based. In this case, the resolution was fairly positive and adopted by consensus, and is not the reason that Vietnam was the initiator that we would not have supported it. So that was one of the positive elements highlighted in the statement, because it was a positive element at the last Human Rights Council. But it doesn't say that with that we have supported the developments of human rights in Vietnam. When we come to the content of the human rights clauses, it refers to appropriate measures that can be taken, and that allows us to calibrate the actions and also to use all the tools that are at our disposal. And I really appreciate the mentioning that it has to be a gradual approach, and that your final objective is not the suspension of the agreements, but it is engagement and gradual approach. And the appropriate measures language allows us to enter into an engagement and a gradual approach. As said by Madeleine, the clause on the fulfillment of obligation that would allow the suspension of the agreement is a measure of last resort, and it has to be taken as such. Engagement remains our preferred course of action. And we aim to maintain the dialogue as far as possible. I would still like to highlight that there have been occasions during which we have suspended negotiations of agreements because of the human rights situation. It comes to mind the Thailand FTA that was for which the negotiations were suspended after the coup in 2014. The Myanmar Investment Protection Agreement, where negotiations were suspended in 2017 when the situation deteriorated in Myanmar. In the Philippines, we have given preference to the GSP process over the continuation of the FTA when the situation deteriorated there. So there have been cases in which, in the run-up to the conclusion of the agreement, it was decided that it was the preferred course of action was to pause and see and work with the country in improving the human rights situation before moving forward. On the specific case of Russia that was mentioned, where, as you correctly said, there have been 11 rounds of sanctions, but no suspension of the agreement. This is true. It's the only framework we have for cooperation with Russia, but I would also like to underline that the last Russia summit took place in 2014. And there have been no negotiations of what was supposed to be the new agreement with Russia since 2014. So de facto, the agreement is there, it's not suspended, but it is not used, but it remains as a framework. As regards the mentioning about the dialogues as being rather secret, human rights dialogue, in fact, I consider are very transparent in two ways. First of all, we have guidelines for the organization and conduct of human rights dialogues. These guidelines are public and have been approved by foreign affairs ministers. There are consultation with civil society ahead of the dialogues and debrief after the dialogues. We often respond to the request of the European Parliament to have in-camera debrief of dialogues on human rights. Most recently, I remember with China, there has been an in-camera debrief, for instance, and we always have a statement. We aim at having joint statements. When not possible, we will have a separate statement when the situation doesn't allow us to come to an agreement. So the transparency is high, and I would like to reconfirm that we stand ready to come to the Parliament anytime you wish if you want to have more information about the results of a dialogue. Also in the dialogues, I would like to underline that our objective is to identify concrete areas of cooperation to be identified during the dialogue and pursued after the dialogue. And this is a way to push forward our human rights agenda with a partner country. And we often do that in follow-up letters that we have with partner countries. We are in the process of identifying that as a result of the Vietnam dialogue, for instance. And that allows us to have a positive agenda with a partner country and a monitoring or a tracking approach. As regards the specific case of India, there we have just resumed the dialogue with India after several years that has been interrupted. We take the point that this is a valuable instrument that we can use to discuss elements of human rights that would then be important for the negotiations of the agreement. On the question about reporting, indeed, we do have an annual report on human rights, which is composed of two elements: a thematic report, which the 2022 is under finalization, should be published soon. And then we have a country-specific report that is only published online. This is available. It's a very important tool that we use to track the progress of our action and the implementation of our action plan on human rights and democracy. As regards the monitoring instruments for progress in countries, we rely, as Madeleine said, very heavily on the international procedures, the UPR review of the Human Rights Council, and the special procedures and body review mechanisms of the international human rights setting. So this is for us a benchmark for to track the progress of each country, and it is a benchmark that we use in our human rights dialogues because we always refer to reports of treaty bodies and special procedures in dialogue with partner countries, but we also encourage partner countries where they have not complied with their commitments to respond to requests or to allow a special procedure into the country. We always encourage the partner country to do so. So it is a mechanism that we use positively, both as a hard tool to see the progress, but also in our engagement with the partner country. So thank you very much again.
Thank you. I will now turn to you, Valentina Stoeva from the Ombudswoman Office. Please go ahead.
Thank you. Thank you very much to the organizers for inviting us at the presentation of the study. We are naturally very much interested in the findings of the study because it very closely relates to a strategic initiative that we carried 2021-2022 regarding the European Commission. So I would like to very briefly remind ourselves what the strategic initiative was about. And I also see that parts of the information that we were able to gather in the context of it are mentioned in the study. So the focus of this SI concerned how the Commission prepared the human rights clauses contained in the trade agreement signed by the EU, and how it monitors and how it does the monitoring and enforcement once the deals are in place, The Ombudsman asked the Commission a series of questions, and we also met with colleagues and the EEAS colleagues to discuss the matter. I would like to comment on a specific aspect. Again, all the information is public on our website. Given our line of work, one of the most important aspects that transpired from the strategic initiative was the question of how the Commission deals with complaints concerning breaches of human rights in third countries with which it has agreements. We heard explanations and we received information about the 2020 reform, the establishment of the Chief Trade Enforcement Officer, and the setup of the single entry point. In practical terms, the Commission also told us that when a complaint arrives, a specific team is set up to make an initial assessment, and that they aim to conclude the assessment within 6 to 8 weeks period, which then is shared with the Chief Trade Enforcement Officer, who together with the single entry point team ensures follow-up. We also learned that the single entry point is available only to EU citizens or organizations based in an EU member state, and individuals and organizations based outside of the EU may contact EU-based organizations and ask them to bring complaints on their behalf. The single entry point, we learned, also can pursue actions on its own initiative. The Ombudsman closed the strategic initiative last summer and concluded that the single entry point, which in theory can handle complaints on human rights issues, does not seem to be suited to handle such complaints, and that the approach in place in the single entry point does not focus on human rights. Because of that, the Ombudsman made suggestions for improvement, that the Commission should consider setting up a new and separate complaint handling portal. In other words, about failures of the parties to the agreements to comply with human rights standards. And she also brought to the attention of the Commission that accessibility, citizen friendliness, and transparency should be key principles when setting up a complaints mechanism. The Ombudsman also called on the Commission to examine how it can facilitate individuals and organizations based outside of the EU to directly raise human rights issues. And given that stakeholders on the ground are often best placed to report problems and present evidence, the recommendation, the suggestion was that this could contribute to strengthening the effectiveness of the EU's enforcement in this area. At the end of last year, we received the Commission's reply. The Commission agreed on the importance of ensuring that stakeholders can effectively share human rights concerns, but in relation to the accessibility of a portal to outside of EU stakeholders for human rights complaints, the Commission said that it must balance the use of its tools and limited resources with the need to ensure that the trade instruments deliver benefits to EU actors. We also heard today the argument that it is considered that the already existing mechanisms and instruments allow the Commission to address human rights issues in the context of its trade policy. The Ombudsman regrets this reply, which did not outline reflection or new thinking or possible new measures to address our suggestion. It was implied that one of the arguments was that there are limited resources, there are a barrier to opening up such a complaints mechanism. However, we wanted to recall that in the course of the strategic initiative, as of summer last year, 2022, we had learned that only 35 complaints had been received under the single entry point. And given this relatively small number, it is hard to see how enlarging the capacity for handling human rights complaints concretely to a dedicated human rights complaints mechanism could lead to such a demand for resources. Moreover, we take note also what was said today, that DigiTrade, the EEAS, other parts of the EU administration already work together in handling the single entry point. And so in this context, for us, it is hard to see how a complaints mechanism dedicated to human rights issues would duplicate the work of different entities involved. We were happy to see that the study presented today supports our suggestion for a dedicated human rights complaints mechanism. We consider that expressly opening a forum for complaints on human rights issues in the context of trade agreements and proper follow-up of such issues could ultimately help ensure that the human rights clauses in the agreements are in action and they're working effectively in practice. Of course, it is for the Commission to decide what administrative arrangements need to be made to such an effect and to handle such complaints. But we think that today's study proposes some key recommendations and tangible recommendations in this regard, and also in what concerns other aspects of the monitoring and the enforcement. And we join in inviting the Commission to reflect on those proposals in order to ultimately ensure compliance with human rights norms. Thank you.
Thank you very much. I don't know which mic I should. There you go. I leave it like this. Thank you for your intervention. I will now turn to Gaëlle Dusepulchre from the FIDH, Permanent Representative to the EU, but also member of the Domestic Advisory Group for Vietnam. So it would also be interesting to hear from you. Have I been too severe saying that the human rights dialogue with Vietnam is a masquerade? Please, you have the floor.
Thank you. So, yes, I will for sure raise the issue of Vietnam because I think it's a school case about how finally efficient are the tools that remain in the hands of the EU at this stage. But before to do that, perhaps I would like to raise the fact that what's the good news of this specific conference, I think, is the fact that it appears clearly that there is no contestation on the fact that human rights are part of the trade policy and is a specific objective of the trade policy. It hasn't been contested by anyone here. And more than that, there has been an agreement even by DG Trade of the fact that we need to have a monitoring mechanism, we need to have enforcement mechanism, and we need to have complaint mechanism. The only issue at stake now is, okay, but which kind of mechanism? And I'm also impressed by the fact that DG Trade raised the fact that in terms of monitoring mechanism, enforcement mechanism, and complaint mechanism, the example of GSP was raised. And taken that specific topic as point of departure, there is absolutely no reason to not enforce the same mechanism, or at least similar mechanism, for FTAs. So perhaps I would like to insist on simply one of them, about the complaint mechanism. The position of DG Trade remains at this stage that simply sending letters to DG Trade, External Action Service, could be sufficient to address the issue. And I think that this kind of answer, and certainly now at this stage in 2024, is not serious, because we have seen how in all other areas of trade policies, it has been recognized the fact that we need a specific complaint mechanism with specific procedure, and that can encompass all human rights. So I think that this answer is not serious, for sure, but it is also not right-based. We cannot agree with the fact that on human rights, the only means or tool we have to be sure that the EU also comply with its own obligation is to simply beg, to simply ask the EU to take a political decision. We need to encompass that in a specific process, and the EU has to be coherent with itself and to adopt a right-based approach. So what does that mean in practice? once again, we can even agree with DG Trade when it is said that it is not time to reinvent the wheel. We have tools, and now we need simply to improve the tools and to ensure the effectiveness of the measure that can be taken. And I think that it was specifically what was proposed in the study. It was specifically what was proposed by the Ombudsman, and it was proposed several times also by the European Parliament. So at this stage, I have one concern. When we have that kind of consensus, what do we need now to have a step further and to recognize the fact that human rights dialogue is not sufficient, and that we need, as it has been provided by other means in other areas of the trade policy, efficient tool. I think that even the European Parliament has perhaps some tracks and legal possibilities to ensure that we have more coherent question and more coherent answer and probably more coherent policies. On Vietnam specifically, when we were negotiating the FTA, one of the arguments made by DG Trade on, okay, we need an FTA, the clauses are sufficient and so on, was to say that, okay, when the FTA will enter into force, we will see how we have new tools to enforce human rights. But we all know here that it's not the case in practice, and that the human rights dialogue is an old tool that is, of course, important, that can create specific area of cooperation, but it's not sufficient to address specific violations that are related to trade. One of them is the capacity of human rights defender and environmental rights defender to document the policies on the ground. When you have trade that have impact on human rights, investment that have impact on human rights, when you have trade that have impact on environment, and that no one can document that, and that when we raise by letter the situation to DG Trade remain deaf to our complaints, that means that the complaint mechanism is not sufficient. So that was the example for Vietnam. I think that in India also we need to be cautious and to be sure that we do not miss finally the opportunity to at least enhance the credibility of the agreement. And one of them will be, of course, we have seen so much progress in trade policies in other aspects, not in FTAs, but in other aspects, like the discussion we have on human rights due diligence, like the discussion we have on a ban for forced labor. Fact is that we need in trade agreement also to empower also the EU to ask specific things to the partner states. At one stage, the EU investor, the EU company will need also to have DG Trade on board to ask specific things to the partner states. And so we need to improve the different clauses, safeguards, and mechanisms that are in the FTAs. Thank you.
Thank you very much, Gaëlle Dusepulchre. I think the two latest interventions call for further reactions from the Commission as well, because the main objective of this discussion is to see where are the missing links, the loopholes, in order to make our trade agreements effective when it comes to human rights violations. And I have to say, I also je reste sur ma faim when it comes to your reaction, Madeleine, because we acknowledge the different tools, autonomous instruments that this mandate has been working on, also when it comes to trade. But nevertheless, I will take again the example of Vietnam, other examples where we have effective backlash on human rights. And especially, you said not linked to the trade agreement, but there I cannot agree, because we've seen that one candidate to the DAG has been arrested. Vietnamese government considering that it would be a critical voice towards the governmental policy. What about this specific situation, for instance? Also, we've seen in Central America that trade unionists have been killed. In Colombia, in Mexico, environmental activists have been arrested and killed also. And there we miss, of course, there's dialogue, importance of dialogue. I think we all agree with this importance, but then when it goes far, as we see it in Vietnam, in Central America, in other countries, and we have either economic partnerships, investment agreements, trade agreements, how can we use those to go deeper? And that is also the aim of this discussion, to see how effective it can become. So, question to you, I think, to go deeper into the recommendations that also have been addressed by the Ombudswoman. And then one additional question from my side, what about pushing for the creation of a CTO-like and SEP-like mechanism in our trading partners, in the trading partner countries? Thanks.
I think the fact that we are discussing this not since yesterday, since quite some time. I mean, I think I will try again to explain it, but it is a fact that we probably don't have the same view on it and appreciation, even if the underlying issue, we totally share it. And I think also on the dynamics and on the approach that it shouldn't be there. I think the point we're trying to make, and this is where we have a different point of view, is that the GSP example cannot be extrapolated to others in terms of monitoring mechanisms. We even don't have the capacity and people of it. It's 11 countries where you zoom in with a very dedicated EU autonomous measure, a preferential agreement that is dedicated to human rights and the fundamental rights. You cannot extrapolate that to a trade agreement. I also think we need to be very careful in putting to the bin or sidetracking the vehicle we have, which is the human rights dialogues with countries to engage, which are also by far exceeding the number of FTA partners we have, dedicated to that by thinking that miraculously, by putting a trade agreement or trade people together, you will resolve this. There is, on all the agreements since 2009, an essential elements clause that gives the leverage. There's certainly discussions on human rights issues, also in the context of trade agreements. I remember numerous, including Vietnam, discussions on it. The Labour Party is in any way, because the fundamentals are part of the GST chapter. But I think that where we diverge in views is to set up separate mechanisms, separate dedicated CTOs, and that type of thing. In terms of creation of CTO in partner countries, that's for them. I believe that under the UN, there are actions plans, and there is, but we are not going to, we can suggest that they have their focal points for that, but it's not for us to demand a third country to set up a CTO a la EU, if it is. The CTO as such, his mandate is to deal with the trade agreements and GSP, so that's his mandate. If we go into a CTO sort of entering more into what I would argue is within the remits of the UN to broadly across the board assess human rights and monitor that is not something for the EU CTO. That we discuss human rights issues when it relates to an FTA. Yes, that happens. So I think we agree on the importance of it, but not in the tools that you've been proposing, and we've been trying to explain it. But obviously you have a different view of that.
Just to add very briefly, of course, the FTA with Vietnam has a clear importance. I didn't want to say that the FTA and the person arrested are linked. What I wanted to say is that by having an FTA, as Madeleine just said, is not that you solve all problems, but you give yourself the tools, the additional tools for a framework for dialogue, and a PCA normally foresees that. So having an institutional agreement in place gives you a framework for dialogue. Does the dialogue resolve all the issues? No, the dialogue is one of the instruments, is a very important instrument that we have, where we can also raise individual cases. And I want to underline that in the case of Vietnam, despite the reluctance at the beginning, we were able to raise individual cases. And I would also like to underline that by raising the individual cases, we have tracked the consequences of it, and the consequences positive. So the European Union raises individual cases. Those individual cases are, partner countries knows that those individual cases are under international scrutiny, and therefore we have seen some positive results in the handling of specific situations. That complements all the other instruments that we have at our disposal, not least the support of local civil society, support of human rights defenders, human rights defender mechanisms in the countries. Can we guarantee that by having a very important human rights defender mechanism that can operate in every country, we can reduce the harassment and killings of human rights defenders? Certainly not. But it is an instrument that we put at the disposal of people on the ground that are at risk, and we use it to the best of our possibilities. We use public statements. We use support to NHRIs in the countries to ensure that NHRIs can be independent and help in promoting human rights and supporting those at risk in the country. So we have a lot of instruments, and the FTA, PCA, human rights clauses is one of those. None of the instruments in isolation would resolve the situation. All instruments put together are making progress in the situation. The progress may not be steady. There is not a consequential factor whereby having a dialogue will result in improving of the situation. Having a settlement will result in reduction of death penalty convictions. There is no consequential link there. But we are, of course, using all the instruments to the best of our capacity to ensure protection and fulfillment of human rights in partner countries. There will always be ups and downs. That's unavoidable. I think that what I would like to underline is that human rights is really core of the foreign policy, and more now than ever before, probably, because if you look at how much human rights is raised in our political dialogues, in our summits with partner countries, how many statements we are issuing, how much activity is done on human rights by our EU delegations on the ground, is really impressive. So we cannot turn the wheel from one day to the other, but progressively, I think that we are recognized as being a powerful force out there to protect and promote human rights.
Thank you. Well, yeah, there's probably a divergence of views on what can still be done and improved. Humbert's women report, we have this study, an in-depth study. We also have a study commended by the Droit Committee that has been presented recently, and that goes into the same direction as your recommendations also. So definitely, I think we have to further work on this. when I was negotiating the EVFTA agreement at parliamentary side, we were told that the ratification of the EVFTA with Vietnam would lead to an improvement of the human rights and that it could be used as a tool. And what I see now in practice, after several years of implementation, it's that it's still not the case. And this is what we need to further work on, I think. I received a question by Claudio Francavilla from Human Rights Watch on the EVFTA. I will read it out. We were repeatedly told that the EVFTA would lead to opening an improvement in human rights in Vietnam and that the human rights clause would have been an effective deterrent mechanism. NGOs warned that the opposite would happen. And in fact, the deal emboldened the leadership and its repression. Now it's not only pro-democracy activists, but also environmentalists who are targeted, with repression only intensifying. Human rights dialogues have absolutely no impact. We had some leverage before the EVFTA ratification, but unfortunately we haven't been ambitious enough. So what now? How can the EU prove that concluding the EVFTA improved human rights in Vietnam when the opposite is true? How will the human rights clause be used, or were we lied to the EU before ratification? And this, goes in line with the question we've been asking before on how to really make use of a tool like an EVFTA, because there we have a concrete example. So at least it should serve as an example, maybe for India negotiations, for instance, that we have absolutely to fix pre-ratification commitments, at least. Also with ratification of the core ILO conventions, as mentioned before, as a minimum, and engagement for a roadmap with the partner country to really engage into concrete steps before the ratification from EU side.
No, I think sometimes it's good to think, what if we would not have had the agreement? I think that's also a fair point to really raise. I happen to have been quite closely involved with Vietnam. Now a little bit less, but if I see where we are, at the time we never thought that we would get a start of the labor reforms. I was there at the meeting with 2 persons in the labor department of Vietnam who nearly begged us, help us to get the internal reforms here. You're not talking about a regular country. You're talking about a country that even doesn't know what freedom of association was those days, who wanted to engage in a reform. And if I look at the steps taken over the last 8 years, yes, it is slow, but we have used our leverage very seriously. So sometimes it's also good to see what have we achieved and not immediately say nothing has been achieved. Support to NGOs, also that there was no discussion. Thanks to EU engagement and support to local NGOs and the DAGs, there is at least hope and the start of something that looks like it. Certainly the EU-Vietnam FTA has triggered ongoing labor reforms by Vietnam. They're slow, but they're taking place. And as I said, the domestic advisory group was initially restricted to a few members, but is now also an example of how the agreement can act as an additional platform to engaging with Vietnam civil society and with Vietnamese authorities for acknowledging its role. So we need to keep on supporting these opportunities for engaging in promoting dialogue in Vietnam. And we believe that at this stage of our relations, the path of engagement and dialogue remains the most constructive way towards better rights for its citizens. But the fact that we have and PCA and FTAs and all these additional structures, one should sometimes think without it, we wouldn't have anything. And if it weren't for the EU, these reforms would not have been there. I know that before us, there was a wave because the US was engaging. They disengaged, and the labor reform was really on the verge of getting into a collapse. So I want to add that.
Before I give the floor back to the speakers, are there questions from the room? I turn to you. So I will first give the floor to Professor and then Gaëlle Dusepulchre for reactions.
Yeah, very brief intervention reflection. I mean, of course, nobody contests, I think, that we do have quite some instruments already. The question, of course, I mean, that was the point of departure for the study. What can be done to improve the situation? Can you reflect about ways to do more than just make the observation that the ground? So the question is, shouldn't we think about additional mechanisms and instruments to make them more effective? And again, here it's a question of thinking about an entire policy cycle, not only having it as a point of reference and having a human rights dialogue in itself. I mean, it's not purpose in itself. It should serve certain purposes. So maybe here it's the question, what could be done in that respect? Last point, maybe we discussed, and also you referred to the fact that there have been examples where the negotiations have been suspended because of human rights concerns, which is all in the period before we have an agreement in force. I think this is what we refer to as this gap between before and after we have an agreement. Before an agreement, I mean, we have these examples. After the agreement, it might at least be relevant as the minimum thresholds to focus more on the principle of non-regression, that you have a commitment that we can't have backsliding with respect to countries with which we have agreements in force. So that might be an additional element, perhaps, that is relevant.
Thank you. I have two remarks. The first one is still on the complaint mechanism. I think that the only argument we had finally today is about capacity and resources. I think it's not a good argument, and at least we need to challenge that and to see. Argument is that still we have other tools to deal with human rights issues. Fact is that in international law, we cannot rely on inefficient tool to comply to obligations. So that's the only remark I would like to make at this stage. And to conclude, I think that the last intervention of DG Trade was really interesting, because when we ask what has been finally the positive impact of the FTA on human rights, the answer was on labor rights. And that is typically what we are saying here. It is because there has been ex-ante conditionality on labor rights, and it is because there is enforcement mechanism and monitoring mechanism and specific clause in the agreement that address labor rights, that you had that specific impact on the ground. And that specifically what we are asking for human rights also.
Thank you very much. I think this concludes perfectly this exchange, because indeed it's how to extend our trade agreements to the broader question of human rights violations, and have obtained commitments also from the trading partners to include that dimension when it comes to trade or investment negotiations, knowing especially, and this is also reported back from the DAGs and meetings I've had with Vietnamese representatives active in the DAGs, but under the supervision of government representatives. So they were not independent at all. Those members were not this is really revealing where we stand, and also the fact that when the day before Commissioner Timmermans went to visit Vietnam on the Green Deal and energy investments, environmental activist was arrested. The candidate to the DAG was also arrested. And I think there are issues that we need as an EU to address seriously, since we have this EVFTA with Vietnam, and since also we made clear that this EVFTA would serve as a leverage to improve the broader human rights situations in Vietnam, and indeed not only, which is of course a good step, but not sufficient in our view, in Vietnam and in other countries that have been mentioned today, to address more broadly the situation of human rights through a trade lens and economic partnership lens. But this needs to be further worked out with the Commission, because we need the Commission. And thank you very much for this exchange, and I'm sure we'll stay in touch to work further on this. Thank you.